And matter of fact, what happened was somehow I got an invite to an appropriations committee Monday afternoon at 1. I responded positively to it, and then all the other members of the appropriations committee got an invite for 1 o'clock, but there was no meeting at 1 o'clock.
We are live.
All right, so we are live. Our first agenda item is the e-file letter from the Judicial Rules Committee, which the chair of the Judicial Rules Committee, Senator Joseph Benning, is with us this morning. And we have Eric Fitzpatrick from Legislative Counsel I think you've all seen copies of the email or letter regarding e-filing, urging the court to delay implementation in Bennington, Rutland, Addison, and Chittenden counties until problems are worked out. The court chose not to. You have posted on our website an email from State's Attorney Mathage when it went live September 1st, and the problems encountered in Bennington County already. With that, I'll turn it over to Eric and Joe to go over the letter. Joe is the chair of the Judicial Rules Committee.
Sure. Senator Benning, do you want me to jump in first? Would you like to go first? Whichever you prefer.
My part won't be that difficult. This was on motion of Senator Sears in the committee that we asked for a delay in implementation of the rollout. The idea of sending the letter was to indicate our frustration with what was being told to us and the inability of the courts to respond and correct those problems. We did not want to see a rollout continue only to exacerbate those problems, and now seemed to be a very good time to put a hold on things until those problems were ironed out before a whole nother group of folks associated with the judicial process get frustrated with the inability to connect the way that they had anticipated they'd be able to. As a result of that motion, the committee agreed to send a letter to the judiciary. Eric drafted the letter, and I guess, Eric, I'll hand it off to you from there.
Great, thank you. Good morning, everybody, and Eric Fitzpatrick with Legislative Counsel here to talk a little bit about, as Senator Sears and Senator Benning have just indicated, the letter from the Judicial Rules Committee to the court regarding the electronic filing system. Just a moment or two of how it got to that point. I'm sure the committee remembers very well. The Senate Judiciary Committee dealt with this issue extensively during the first part of the session before we took the summer break. The electronic filing system being proposed by the court and implemented. You then passed that first quarter budget, Act 120, which included a provision requiring the judiciary to report to the Joint Fiscal Committee and to Justice Oversight by October 30th, after having met with the Bar Association and other system users to get feedback and also to get specific comments about alternatives to the fees of the electronic filing system. So that was in Act 120. And then over the summer, the Judicial Rules Committee was taking testimony on some proposed amendments to these rules themselves, to the electronic filing rules. Now, the amendments themselves proved to be mostly technical, but during the course of that, the committee thought it would be useful to hear from some users of the system, from folks who were actually out in the field practicing with the electronic filing system in the counties that it had been implemented so far, which I think were Washington, Orange, and Windsor, if I remember correctly. So committee did that, heard testimony from, particularly extensive testimony from the state's attorneys and the defense bar, executive director of the state's attorneys, John Campbell, Defender General Matt Valerio, also particular state's attorneys and contract defenders with the Defender General's office. And based on that testimony, that there were significant numbers of issues and problems with the system and that people had not been properly educated in how to use it. That's when, as Senator Benning indicated, the committee made a decision based on a motion from Senator Sears to send a letter to the court saying, recommending strongly that the rollout of the system to additional counties, which I think was planned for October 15th and September 1st, sort of a combination of those two, be delayed. So they would essentially put a pause on the rollout of the system until these identified issues and problems could get remedied, and until people who use the system could be taught and educated sufficiently in how to use it. So those were sort of the criteria that were suggested by the committee that would be met before the system would be spread out to any additional places in the state. So I drafted that letter. That's what you have in front of you. I think the letter speaks for itself, and it really just says what I just articulated, and Senator Benning did as well, which is that based on the testimony from users that the committee heard, and I should add here that there's a lengthy addendum to the letter. I then solicited input from the same witnesses who had testified, and based on testimony from John Campbell, Matt Valerio, as well as submissions that were provided by Jordan Levine, who's the Windsor County primary public defense contractor, Tracy Shriver, who's the state's attorney in Windham County, Ward Goodenough, the Windsor County state's attorney, and Terry Corsones, the executive director of Vermont Bar Association. I integrated all those comments into one document and then put that in an addendum, which you also have, so that the court would also have this list of what the specific concerns and problems were that people were having with the system that they could use to go forward. So that all was sent to the court on August 28th. And as I say, the substance of it is just as we've said, that the strong recommendation from the committee, from the Judicial Rules Committee, that the system not be extended to any additional counties until these issues are fixed. And that's really the gist of it.
Just want to kick in, Dick, if I can, that
Yeah, please.
I've been involved in the court system now for going on 37 years this April. And it is an extremely rare event that in the criminal area, both the prosecutors and the defense completely agree on something. And I'm sure John Campbell and Matt Valerio will agree with that statement. But the bottom line is we have a system that is broken and it needs to be fixed before it continues to be rolled out. And if we continue to roll it out without fixing those problems, the great concern here is that we are only extending the number of people who are going to be commenting. I should also add that I'm a member of the Defender General's listserv. Some of you may have been getting letters from attorneys because I had suggested to the listserv that this meeting was going to be happening. And if you're receiving letters from defense attorneys with complaints, that's probably where that was originating from, my contact on the listserv.
I'm just going to quote from Erica's letter or email to me that's been posted. To date, we have not received any hands-on training or demonstration. They provided a PowerPoint over the summer that dealt mainly with civil practice. The police organizations have received zero training or information on the new system, even though law enforcement is directly impacted in what information they can get. I'll be interested to hear how public defenders and contract attorneys are doing. Preparation for this project with users of the system has been dismal. The largest segment of the state is rolling out today, and my office is at a loss as to what we're supposed to be doing to help make this as easy as possible. It's really unfortunate that this is happening in the middle of a judicial emergency because everyone is already working as fast as possible to adapt and not get discouraged. Have I frozen? Or Senator? So, I mean, I think that leads me to our, are there any questions or comments? John Campbell, Executive Director of the Vermont Defense. Excuse me, you're not the Defender General. You're the Executive Director of the State's Attorneys and Sheriff's Department.
Hi, yes, John Campbell, Executive Director of State's Attorneys and Sheriffs. Thank you, Mr. Chairman, and the rest of the committee. One thing if I can start, kind of touch upon what you just said, Senator Sears, and or I should say what Eric Marthage said. And right now, the morale in our offices is really severely being taxed. Mainly because of the COVID. There's issues that are going on, but now, with this and with the uncertainty and with people feeling like they don't know how to do their jobs, it's creating some serious concern. I We have, as you said, we had the letter, which, by the way, I think Eric did a great job putting this together, outlined the issues. And some of these issues have been, I guess a couple of them have been taken care of since we last met. I don't know if you want me to go down to discuss ones we're not, or just give you an overall view of what we see
We don't need training. We just don't like.
as still problematic.
Sorry, Pat, you're still on, you're not muted, so we heard you that people don't need training.
I didn't.
I thought that was you saying we didn't need training.
No, I didn't say that.
Oh, okay, good.
And
Good.
we've offered a lot of training,
Okay.
and hundreds of people
Senator,
have signed up. Yeah,
well, Senator King,
Pennington.
thank you. We'll get to you later.
So,
John, please continue. I'm sorry for the interruption.
No, thank you. A couple of issues. First of all, one of the things that I think has been positive that the legislature has done was we've been working with Dan Smith from from Joint Fiscal. He's been helping them out. He's been available on other projects, I guess, prior to this one. And he has been acting as liaison, trying to work us through some of the problems. That's helped, but there are still the major issues that we're talking about now. Ms. Gable's going to, she said that there's been lots of training, and there has been training offered, but the training has been offered on using the WebEx and using a civil model. I think one was a paternity action, one was a divorce action or something, and while that might have some basic skill training in it, it certainly doesn't address all of the nuances of a criminal practice or criminal or issues that we find in the criminal arena. Now, to give you kind of, I think that this would sum it up the best for what just happened, is I talked with Erica Rose Kennedy from Rutland, and Sarah George and Jen Buford from Chittenden County. And I can tell you, so that was the first couple of days of rollout, and it is not going well at all, as Erica pointed there. This is Jen Buford, who is probably, I consider, probably one of our top administrators. She's got more experience than most, even most of the state's attorneys. And she is just like, she goes, I've never been in a position to where I felt so helpless in dealing with this situation. She mentioned that she spent over 3 days trying to figure out how to get what's called elevated access for her office, for personnel and their victims advocates and other personnel. And she called their help desk, and they told her it can't be done the way she wanted to do it. And then 2.5 days later, they evidently came back and said, oh yeah, no, you were right. But you have to do this, and you have to, they added a couple of things. Then there's also, I guess, the way the docketing is, usually you'll see in a criminal docket, you'll see that it's a criminal case, and you'll see also the county. So if somebody who's a layman is looking to find out, about a criminal case that happened in Windsor County or Bennington or Chittenden County, it will not only have the docket number, but and the criminal, CR for criminal, but it'll also have the county designation. And I guess they no longer have that, which she feels will be a problem for the public. And then it creates still search terms is trying to find a case. Is, I guess they use a system that's not set up to handle the Soundex type search, and it takes them significant amount of much more time to search the system to find information that they need on cases. This is probably one part that's the most disturbing, because in our meetings that we did have with with the court, they told us again that law enforcement has been advised about this and been trained, and that they're, fully aware of the whole system. And I'm just going to read this right straight from her email, if I could, Mr. Chairman. It says, lastly, I was told by one of my admins yesterday that an administrator from one of our local law enforcement agencies called the courts online, or called because courts online was no longer working for her and she needed information. So her admin politely told her that the courts online was being phased out in Chittenden, and that law enforcement was supposed to have received information about this new public portal. The law enforcement administrator had no idea what she was being told. I had been assured on several occasions that law enforcement was well aware of this changeover. Now we are going to have to politely refer law enforcement to the court to get the information that they're looking for. Again, there just seems to be a major breakdown from on the system. But then also the second problem is, and I think this was brought up in our at the judicial rules hearing, was the considerable work shift. Workload shift from the courts to us, specifically in filing the initial packages. As Tracy Shriver said from our Windham County State's Attorney, I think she put it best with the analogy of a sandwich. Before, currently, and actually with all counties that are not Odyssey counties, they would take a initial package that we would have for the police reports in order for us to file charges with the court. We would have a package, we put it together and just hand it over en masse to the clerk, and then they would do whatever they needed to do with it. Now what they want us to do is take what we get from law enforcement or other agencies, put it together, and then we have to individually take it apart again and separately file each. I think there's 3 different filings that we now have to do. And so what used to take, let's say, maybe 3 minutes, because we actually had 2 of the counties start to time this, what it would take on average of 3 minutes to put a package together, now takes anywhere from 15 to 18 minutes to do that. Again, that someone might say, okay, well, big deal. Well, it is a big deal because we have limited staff, and if you take that times the number of cases that we have to file, it's just an inordinate amount of work. And also, finally, I just want to say that there was a question about the API, which is the interface between our Justware case management system and the courts. And the only thing that affects is just the initial input that we do as an office. That once our API is done, when one of our admins enters the information, the data for a case, they won't have to input that data twice. But that's more that we would have had the API in place now, except for a security issue that happened. Not related to us, but happened, and that ADS is putting on hold on any implementation of external software patches. So that's all I can say, unless you would like me to go through the list, which I believe the committee has a copy of that. And all I can say is that kind of to echo what Senator Benning had said, it's not often that you get both the defense and the prosecution to agree on things. And, this is something that I don't think it's being nitpicky. I don't think it's trying to hurt anything. We all believe, I think very strongly, that e-filing has to happen. It is essential, and it's the way to go into the future. But if you don't do it right, and if you have a bad foundation, it's just not going. It's going to be problematic for a significant time to come. Not to mention the toll it will take on those who have to use the system.
Thank you, John. I don't know if there's any questions for John Campbell, but it's a good segue to the defense bar, represented by Matt Valerio, the Defender General. John, thank you again. Matt, please feel free to go ahead.
Yeah, thank you. And this will be a bit of a repeat from what I had said at the Judicial Rules Committee, but we also recognize that, e-filing and an updated case management system is going to be something that's necessary. and it's welcome. The unfortunate thing that we've encountered is pretty much everything that John Campbell talked about, from training issues to functionality issues, and the like, and the fact that within our system, because we have a very hybrid sort of system, we have state employees and staff offices, and we have contract attorneys who provide primary public defense services, and then we have contract attorneys and ad hoc attorneys who provide conflict public defense services. There have been trainings, and I will just reiterate what the people who have taken those trainings and immersed themselves in those trainings have said, is that they're just wholly inadequate to be able to implement the system currently. As a result, you heard, those of you who are on the Judicial Rules Committee, from Jordana Levine, who I had designated as a person, well, early on, her firm designated her as the person to learn everything she could learn about the e-filing and Odyssey project, and make sure that she would be able to inform her firm about everything that that they would need to know to make sure that they could use it. That was relatively early on, and because she's a primary public defense contractor in her firm in that county of Windsor County, I then got a hold of her and said, look, I need you to learn everything there is, so that ultimately, and I don't care if you learn it from the judicial trainings or however you have to do it, but we've got to learn how to do this. And so she immersed herself in the process, and probably knows as much, if not more, than anybody in the state about how to actually run the program, and both e-filing and Odyssey, and the ability to, as John talked about, get elevated access to information that defenders need to be able to get to see across dockets across the state and the like. And after doing that, she came up with a list that she submitted to the Judiciary, to the Judicial Rules Committee, that was 2 pages long, of some of them very serious problems with functionality, and these are issues that were not delved into in training. The training is very cursory, and it puts people at a loss, where if we say, all right, we're going to start on September 1st, have you done the training that's been out there? It wouldn't matter if you did, because you don't know how to use the system. This is not a matter of a bunch of people who aren't capable of learning and who aren't smart folks. All of these people are smart people who are willing to do what it takes to make sure they understand what's going on. And it's just not happening. So what I've planned to do is to have a Defender General's training in September, led by Jordana, to try to get as many of our people up to speed on the issues that are actually relevant to the defense and juvenile court dockets that we're dealing with. But that doesn't even cover and we also deal with a civil docket, obviously, in the Prisoner's Rights Office. So, I don't feel like I can wait around for the judiciary to put together a training that's sufficient for us to get the job done, because it's been some number of months now, and that's not happened, and I don't see a amenability to doing that, or even talking about it. So we're going to try to do it ourselves, and maybe we'll miss something, but it would be helpful if we had some time to be able to do that. We have attempted to use the court's route for training. It clearly has not worked. It was not sufficient. And so now we're at a position where we're going to do it ourselves. I will say as well that what we're hearing is that there is again, as John talked about too, a shift in workload. I think it's probably stuff that the clerks used to do or made available to the defense bar regarding information across dockets across the state. So if you have, for example, if you have somebody come in on a warrant in Windsor, you're going to want to know if they have cases in Chittenden County or another county, and if those are not on the system yet, even if they are, we're hearing that those dockets are not showing up when you do a search. So bail decisions and the like are being made without the complete information that is necessary to make those decisions. That's put a lot of extra effort on the staff offices, because what they have to do is kind of manually call around to the other offices to try to find out, hey, are there any cases for this guy in this office? He's telling me there are, but nothing's showing up in the system. And so there's a little bit of detective work, probably more than a little, going around. Now, for the first 3 counties, those are relatively small counties in the state. When I heard that Bennington, Rutland, and Chittenden, and Addison's small, but we're going to hit basically around now. I was like, oh my God, I can't imagine, with Chittenden having a third of the state's criminal caseload, what's going to happen when people really aren't ready for this. So, that's the feedback I'm getting. But again, I think this is essential to get done and get right. I just don't think we're there yet. And that's what I'm hearing from the field.
Thank you. I don't remember a time in my years as a member of the Senate Judiciary Committee or as a member of the Judicial Rules Committee or any other committees when we've had this kind of issue with the administration of the courts. And so clearly, after the letter from our discussions in Senate Judiciary, and then the discussion with Judicial Rules when the rule was promulgated, I'm actually somewhat dumbfounded that it went on without having the preparation for the practitioners. I'm not a practitioner, so I don't know, but both you and John Campbell represent some of the practitioners in the criminal justice system. Terry Corsones represents the Bar Association, and she's our next witness. And I've heard from 1 or 2 civil attorneys who are dealing with it in civil court in Bennington County, but I'm sure I'll be hearing a lot more in the coming days. Terry, if you'd like to, I'm sorry, any questions or comments from Matt or comments from John? Joe?
Just to Matt, you said you were going to do a training in September. This is September.
Yeah, I know.
The legislature is supposed to have a drop dead adjournment date of September 25th. I would love to be at that training. I don't know if there's any way to accommodate after September 25th, but I'm really concerned about my own ability to get into this, even though it hasn't been rolled out to our county yet. But I just hope you can keep that in mind somehow.
Yeah, I'm I was looking at it was going to probably be somewhere in the last 2 weeks. The date's not set, so if it's the 28th, 29th, 30th, that wouldn't surprise me.
And by the way, I wouldn't count on the 25th.
Okay.
Well, also,
I hate to hear you say that, Dick, because this is getting really to be a serious problem for those of us who are trying to maintain a
No,
living.
no, no. I understand this is a problem. I'm just saying I wouldn't count on a drop dead date of the 25th. My experience says that you never know what's going to come before you towards the end of a session. And this is the end of the session, hopefully. But, you know, it's hard to predict what might be out there. So I just caution us all for planning things. I think we're safe to plan things the first week in October, but I'm not sure I would plan things for the last week of September.
I object, Your Honor, for the record.
I appreciate that.
And Senator, this is John again. If I could ask Matt that if he could include us in that training, because Joanna, I agree. I don't think there's anyone more knowledgeable about the system and some of the problems. So, boy, I tell you, we would like to have someone be able to provide that training to us as well.
Yeah, we might want to do 2 separate ones.
That's what I figured. You guys are always trying to hide something, you know.
Well, you know, there is something about like being on different sides.
Just
I don't know. I was at a conference where both Fred Bragdon and Erica Mathis were sitting at the same table, Matt.
Was there alcohol?
No. No, there was no alcohol.
Thanks again.
All right. Without further ado, Terry Corsones.
Great. Thank you, Senator Sears. In as much as the topic for today is the letter from the Legislative Committee on Judicial Rules, my comments will be based on that and will indicate why the bar certainly supports the letter and the recommendation. And I'm basing my perspective on the experience I've had since—
Harry, you keep fading. I can't hear you. I don't know if
Okay.
it's my computer.
Can you hear me better now?
A little bit.
Do you think it'd be better if I phoned in then and just spoke that way?
Now I can hear you.
No, you're
Okay. Is this better?
Yep.
Great. So I'm going to base my comments on my experience and the difficulty and the delay that I've experienced in trying to follow up on the Act 120 directive for the judiciary to meet with court users. The bill was signed into law on June 30th. I emailed Pat on July 1st asking, whom do I contact and when can we set up the first meetings? Peggy has attached the email string since then. That was July 1st. It was not until after the letter from the Legislative Committee on Judicial Rules went out late Friday that I got an email within an hour asking for dates for our first meeting in September. I sent out a doodle poll and we'll be setting up those meetings, but basically the past 2 months, in my view, have been wasted when there could have been an opportunity for court users. And we've had 2 distinct groups set up, ready to go since early July. One group is for court users, and we have representatives from each of the dockets, from the Access to Justice community, from the self-represented litigant community, all different perspectives, ready and willing to meet with the judiciary to identify what the issues were and to propose solutions for addressing those issues, improving the training. The second distinct group that we've had set up since early July was an alternative e-file fee group that was supposed to meet with the judiciary to examine the alternatives to the per use e-filing fee. That was the subject of that extensive e-filing fee study report that your committee thankfully requested, and that was submitted May 15th. Neither of those groups has met, even though we've been asking for meetings since early July. I was found out August 31st that each group will have a 2-hour meeting slot, and that's it. And when I asked, well, shouldn't the alternative e-filing fee group, it will likely take more than 2 hours to examine alternatives and to ideally come up with a solution. And you'll see in the email, the response was, the purpose of the meeting is not to solutionize. It's to gather information. In other words, to check off, yes, we've met with you. It seems to me, if it's going to be limited to our meeting, that we've met with you and we will go on and issue our report. So we're discouraged that this opportunity that the legislature presented for the judiciary to meet with court users, people have been using the system day in and day out for the kinds of things that Matt and John have identified as issues that need to be addressed. That opportunity has not been taken advantage of, and it looks like we're going to have 2 hours to meet, and that will be it, and that our purpose is not to help to bring about a solution. So I also included, just as an example of, as of August 31st, an email from one of our court user members who identified, as of August 31st, very basic issues. You've heard about it in the criminal docket, her not having received a notice of hearing, alerting her to a hearing in a family case, of her not getting an entry order, granting a motion to lift a stay in an eviction case. And she said, I've attended the trainings. I've done my best to follow through. These things are not happening. And she repeats, or she states in her letter, and I agree, that when the flaws are worked out, this should be a great system and should benefit the public. But the flaws have not been worked out. And it's almost like there's a resistance to meeting to work out the flaws. But if they can be worked out, we stand ready, willing, and able to do what we can to help. One suggestion would certainly be for the trainings to be able to identify, here's what's missing in the trainings. Here's the information that is not being spelled out for whatever reason that would be very useful to court users, not just attorneys, but pro se litigants and everyone else. But we're not given that opportunity to provide that input. So again, just from my perspective and my experience from working with trying to set up these meetings that the legislature directed on June 30th, it's been discouraging. And that's why I would also support the recommendation that it be delayed until what has been shown, or what has been described as a pilot in Wyndham, Windsor, and Orange, that it served the purposes of a pilot. Identify the issues, fix the issues before it's then expanded. Otherwise, what's the purpose of a pilot if you don't fix what issues show or become apparent before you move on to the next stage? I submitted a memo that spells that out with the attachments in the email string, but that in a nutshell is the reason why we would support the judicial rules recommendation.
Thank you. Questions, comments? Again, I'll say the same thing. It seems as though what used to be a collaborative working relationship between the bar and the courts and those who have to deal with the courts has been frustrated. And as a member of the Judicial Rules Committee, I'm disappointed that the court did not respond to our letter. But Pat Gable is here and is our next witness, unless there's questions for Terry, Matt, or John. Pat, I'd like to hear from you. You're muted, Pat. Speaking of getting electronics right, we all find ourselves muted from time to time unintentionally. Thank you.
You're welcome. As you know, when the Legislative Committee on Judicial Rules took up these issues, it was scheduled at a time when I was unable to attend and Judge Gerson was unable to attend. And that was really unfortunate. Although the kind of information and the way it's been presented, I don't see how any of those issues could be responded to in the context of this environment. As you know, although the executive branch and the legislative branch are political branches of government, they're constitutionally designed to be that way. It's intended to be that way. The judicial branch of government is not a political branch of government. We're not designed to be a political branch of government. We're not managed that way, and we're not resourced to engage in political campaigns. Instead, what we're doing is we are trying to manage the administration of justice in a business-like way. We feel that our responsibilities are both to the users of the court system and the taxpayers of the state. And our management of the system is guided by the principles of judicial administration that were adopted by the Supreme Court a number of years ago. And our presentation to the legislature 4 or 5 years ago, whenever that happened, about putting forward a next generation case management system, was in the context of our mission and our commitment to do what the legislature asked us to do. And as you know, what the legislature told us loud and clear, and with no exceptions, is they wanted us to engage a vendor who had a proven system in other statewide judiciaries, get a system that's called, off the shelf, so to speak, and then the system is configured for the needs of a particular judiciary. States are different, they have certain different needs, but the systems in general have the same needs. We are very proud that, unlike the various phrases I just heard about a broken system and issues like that, that it's really the opposite of that. Our rollout of the system has been, and I'm talking now about the case management system project overall, because I realize that not everyone will understand that there are different components of that system. So the next generation case management system includes a case management system which helps replace our failing legacy system that has documents on paper. And now our cases will be electronic. They'll be digital files, not paper files. And that's the way they are in the current WOW counties, Windsor, Windham, and Orange. And that's the way they're going to become in what are called the Brace counties, Bennington, Rutland, Addison, Chittenden, and the Environmental Division. And in that context, the rollouts that we've had and the operation of the system, although it's as challenging as any big transformation will be, has been a tremendous success. We've done what the legislature asked us to do, and we've done it on time, on schedule, and still on budget. Having a project, a major project like this, be successful in that way requires enormous advanced strategic planning and budget planning, and it also requires advocacy. It required us to come to the legislature to present to all the committees, to talk about what we wanted to do, to get the various kinds of direction and advice that the committees of interest had, and then to go back and actually produce that. And if it hadn't been for the legislature actually believing in us and making this investment, we wouldn't be able to produce this important transformation that benefits both court users and the taxpayers. And in this committee, in this committee, we haven't really had a chance to talk about the judiciary and how we've been doing during the pandemic. I realize legislative time is very short and there are various priorities, But the impact of the pandemic on the judiciary has been, of course, extraordinary, as it's been on the legislature. And through that, we've had these incredibly dedicated and talented people who work in the judiciary. The people who work in the judiciary on this project in particular, but also across the board, include judicial officers, court staff, special project team members, and that's an expanded team as we have developed the expertise in the Southeast region. I want to say to you and to all the people who will be watching this public video that the characterizations of their work in this committee have been inaccurate and have been designed to advance certain interests of the people who are testifying that really are not related to e-filing. Because as I started to say, there's the case management system, then there's the portal. The portal is a separate product as a part of our rollout. And unlike now, when people have to pay to go online to see certain documents, the portal allows people with the appropriate permission to go online as a part of the whole system and see documents electronically. And the e-filing piece is the third piece. It's a product used in many states around the country very successfully by state judiciaries. And all of these products provide different aspects of important changes that through the pandemic are essential. It's only right now in the Windsor, Windham, and Orange regions that judges and court staff can actually work on files even though they're remote. Soon that will be true because, as we've said, we're right in the middle of the rollout of the case management system in the western part of the state in the environmental division. This will tremendously increase the capacity of the judiciary to work remotely during the pandemic. And even when there comes a time, if there comes a time, we all have hope and optimism that there will be a time when social distancing is not important. Even then, we've learned that there are certain times and ways that being able to participate remotely in certain kinds of meetings and proceedings is actually more effective and efficient. That's particularly true in Vermont, where we find in the more rural parts of the state, it's very difficult to find lawyers who work there. It's very difficult to recruit lawyers to become judges from those places, and yet we want to have equal access to justice for everyone in all parts of the state. And so these technologies that we're working on are going to be that transformation. And the people in the judiciary, from the top to the bottom, are very proud of the work of everyone. And our project team includes docket clerks, it includes case managers when it's appropriate, it includes management people, it includes lots of people out in the courts, judges are very involved. And so I think that's the most important message that I can give all the people who have an interest in the judiciary to understand after hearing months and months of characterizations of their work with which we don't agree. I'd like to turn though to some of the specific issues that were mentioned. And I recognize—
Well, before we do that, I'm trying to understand the reason that you and the judiciary didn't delay the rollout in Bennington, Rutland, Addison, and Chittenden counties. That's what the question was. And what I'm hearing now is it's because the Judicial Rules Committee is political and the court isn't. I haven't heard the reason for not delaying until the system was ready for it. And
Senator,
I'm missing something, I guess, because
I can explain that to you. So your letter addresses the rollout of e-filing. What we're rolling out this week is the next generation case management system. It's not e-filing. What we're rolling out this week is the capacity of the courts to create electronic files, not the way that lawyers enter documents into cases. Just as in the Windsor, Wyndham, and Orange regions, we rolled out the case management system and then had a separate rollout, I think it was approximately a month later, give or take, of the e-filing system. Because the way complex technology projects work, there's only so much you can do before a rollout. Then the continuous improvement occurs when you actually turn the system on, move to the new system, and then work in real time with a continuous improvement model to see what parts of that system work the way people expected, what parts of the system don't work in the way people expected. And when that happens in the latter sense, did that happen because the system wasn't configured in the way that people thought it should be, in which case that can be fixed by configuration. Or it might be, no, the system was configured in the way that it was intended to be configured, but we find in real life, as we're starting to deal with cases, issues that had not come forward before. Then we work in real time, working with all the partners who are involved to work on those issues one by one. Some of the issues, actually many of the issues that were brought forth in the letter from the Rules Committee, which we're still reviewing, some of those issues actually have nothing to do with e-filing. Some of those issues are based on people not liking the way the current court rules are designed, and I could give you an example of that. An example of that is the complaint about something that one of your witnesses called a sandwich, which means that they get documents from law enforcement and they're required to put it in a certain format before they file it with the court. That's actually, that issue has been around for 12 to 18 months. And the reason it happened is because the legislature passed a statute governing VCIC. And VCIC and the statute limit the information that can be made public from information that comes over from law enforcement. And we learned, much to our chagrin, that our process was not sufficiently protective of that confidential information. And so the public access to court records rules took up that issue. And in order to comply with state law and FBI requirements, they came up with a requirement about the way states' attorneys need to provide information. And this is, the common language for this would be the rap sheet. There's all kinds of information in the so-called rap sheet. Number one, some of it shouldn't even be coming before a judge because it's not reliable information, it's third-hand hearsay and the like. But also, that information contains information that both state statute and federal regulations prohibit from being public. And so this has been around for 12 to 18 months. And that issue continues to exist. It has nothing to do, it wasn't created by e-filing. A second issue that's arisen is that a number of the things that you've identified in this 50 question list are actually things that are covered by the rules. You can find that there are exceptions in the rules to e-filing under certain circumstances. And so if you read the rules, you'll realize, yes, sometimes you can paper file if you qualify under the exceptions to the e-filing rules. So a lot of the issues relate to the current rules or current statutes and can be addressed in that way. So some of them are like that. They're not related to e-filing at all. A second group are related to the operations of e-filing. And so the way we work, and this is true of any complex technology project, We then work with the users and go through the list. And this is something we've been doing with legal aid. As we go through and understand how the configuration impacts the workflow for legal aid, one of the questions is there a way that we can modify that so that the rules are still honored, the statutes are still honored, the operation of the system still works, but it makes it easier for them. And so we've been, interacting with them at the level these issues should be raised, not with people like you and me. These should be happening at the project level. And differently from the testimony that you're hearing today, we're doing that all the time. We're interacting with users all the time. We're problem solving all the time. We're making corrections and changes. So there's another group of those 50 questions that actually were asked a long time ago. They were responded to, and in some cases they're not relevant anymore. In some cases, perhaps the answers were not what people wanted to hear, but some users think that this is going to be a customizable system and we can just make endless changes. And that the legislature didn't want that because they know that we have an evergreen system, that Tyler Technologies is constantly working with the states to constantly evolve their systems. And so it's very risky to have customization that takes you off the general releases that are issued. Because what happens is when a new release comes out, it breaks all the customizations and the system goes bad. And so one of the things we're doing as a part of our process, if we can't fix it, let's say we want to fix it, we've gone through that review of lists and we say, oh no, this is an issue we'd like to improve, but we can't do it right now because we have to finish the rollout. Then it goes on the continuous improvement list. Barry Dunn, who is our external project manager and has done other work for the state of Vermont, has been engaged to conduct the e-filing survey and outreach and focus group consultation that you requested in the last, I don't even want to call it the last session, when you were here in the spring. And it's part of the first quarter budget bill, I think. And they have a very professional approach to reaching out to as many people as possible. The surveys have not only gone to the Bar Association, but have gone to as many users as we can identify. The surveys will come back. Very Dunn will then meet with focus groups of each of these users so we can identify what the issues are and do that same kind of triage we just talked about, which is how do we classify all these issues that are raised? And so to the extent they are operational issues, then we will likely come to the legislature to say, maybe we need resources to address these operational issues. Maybe we don't. A lot of it depends on what they are. Finally, there's also a big issue about training. And the training has to do with both external parties, but also internal parties. We're in the middle of a major transformation during a pandemic. This transformation is vital for us to deliver access to justice during the pandemic. And yet the same workforce in the judiciary is not only running the court system, it's now supporting two different systems until we are fully rolled out, which we hope to be in the trial courts late in the winter, early in the spring. And we're also still teaching and learning to the people who work in the system. In addition to that, we've scheduled a number of trainings and people sign up for it. And so it's very interesting to see who's signing up for the trainings and who isn't. And so we have a lot of prosecutors signing up for the trainings. But you had mentioned Erica Marthage writing a letter, which I haven't had a chance to look at. Bennington is one of the groups that hasn't signed up for the trainings. And we've got like a bunch of them scheduled out to accommodate people's schedules. So training is a two-way street. And I would like to say that I know our project team reached out early on to Jordana and said, Attorney Levine, you've indicated you're worried about problems in the system. We would be delighted to do a custom training for your office And she rejected that and said, we know how the system works. We don't need a training. There are just things we don't like that we want you to change. So we simply don't have enough time in the time that you allot to the judiciary to talk about these things, to refute each and every item. And a lot of it I wouldn't want to refute, in the sense that we need to collaborate with stakeholders who are committed. And we used to collaborate with the state's attorneys. You know, our project started at a time when their executive leadership group apparently was different, when we had relations with the state's attorney's office that were collaborative toward this model. And that's the way the justice system is going to improve in Vermont. The legislature has authority in an area that could really help. And it's not so much in this administrative sort of being in the weeds of how to continuously improve the system, but it is about resources. So you look at other states, and some of their justice systems actually have a central information holding place electronically, where all the people in the system, can find the warrants and the conditions of release and all that. And that's because the Department of Public Safety in that particular place actually had the strategic vision to develop a system like that and advocate for the resources. Likewise, as I believe you've heard before, we've been trying to work collaboratively with the state's attorney's office so that they can set up a data exchange with us that is similar to the way this is handled in other places, so that a lot of these issues they don't like about e-filing would be irrelevant, but for reasons that they know best. I'm not involved in their planning. That's on the list. They want to do it, but they haven't done it yet. And so if it's a resource issue, if the state's attorneys need more resources in order to be able to make a transformation that way, or if the Defender General's office needs more resources, that's an area where the legislature, I think, does have power and authority to improve how our justice system works. And so I would like to say that I look forward to reading this letter and to talking to the scores of people who work in the judiciary about the issues that are raised. We want only to improve. We know that we're challenged at this time of the pandemic in particular to meet the needs of Vermonters. We've always been challenged due to resource issues. But the one thing about the judiciary is that, and I think it would be difficult for you to say otherwise, all the judicial officers, all the people who work in the judiciary are committed to a goal of excellence. And we will work with any party or partner that has that goal and also has an understanding of the taxpayers' needs, which is to do it in the most cost-effective way possible, and the user's needs to do it so that people do have access to justice everywhere. And so we're not perfect, we're far from perfect, but I feel that the kind of testimony you've been entertaining in these hearings has given a misimpression to the people of the state of Vermont about the nature of the fabulous workforce that we have in the judiciary and how dedicated and committed they are to access to justice. There are, again, scores of people working 7 days a week since March on this and on the pandemic and everything else. And we can all disagree about the details, but I don't think any of us would disagree about the goal, which is that we would have a justice system, both a criminal justice system and a civil justice system that function well. And we're happy to put our hands across the border or boundary or whatever they're putting up between us and them to make that happen. But they need to do it in a way that respects the work ethic and the talent that is in the judiciary and has worked on this system. So we look forward to looking at this letter. We look forward to engaging. We don't have to do it in committee meetings. We can do it one-on-one. All those things are something we'd really like to do. So we welcome that.
Yeah, I'd like to make a couple of comments and then Senator Benning has a comment, I think. I just want to respond some to the legislature told us to do it. If my memory serves me correct, Justice Dooley, before he retired, long before he retired, spent a lot of time, and I'll use the term, meeting with the legislature to try to convince us that we needed to go in this direction. So I don't know that it was the legislature telling you to do it. I think the judiciary collaboratively working with the legislature eventually rolled out. And
I
so
agree.
I just want to make clear that it wasn't the legislature coming up with this brilliant idea, forcing it on the judiciary. It was a collaborative effort. It's the rollout that is the troubling portion. It is not the idea of moving to an electronic case system. Our data is horrible throughout the criminal justice system, whether it be in the corrections department or wherever. That's one of the findings of Justice Reinvestment 2. The data was lacking to make some good choices in terms of changes. So I don't think there's any disagreement about the goal, at least from my perspective as the chair of this committee, and having tried to work with both the state's attorneys, defender general, the bar, as well as the judiciary in the rollout of this. It's the rollout. So I want to make that clear, Pat. And I'll then, Terry has asked that Jordina be given an opportunity to just make a couple of comments, but first we'll hear from Joe. And Peggy, I don't know how to get her into the meeting.
Who do you want to invite, Senator Sears?
It was on the chat.
Jordana Levine.
What? I'm sorry, what's the name?
Jordana Levine.
Levine.
Oh.
We heard from her at the last meeting. She's works for the
I just sent her my invite if that will work.
Yeah, that should work. That would be great.
Okay, so I just sent it to her. Okay.
Perfect.
Go ahead, Joe, please.
Pat, I want to go to your first comments about this being a political maneuver.
I didn't use that word maneuver.
Well, you used the term political, and I want to assure you this was not a political move on my part by any stretch. The Judicial Rules Committee meets not necessarily on a regular basis, but when rules are generated or promulgated, you have a group of rules that are assembled, and then all of a sudden I and the committee staff people meet and talk about when is it time to deal with all of these issues. And we recognize that the legislature was reconvening, and we wanted to be able to meet because we were receiving so many comments about this subject that we knew we would have to meet before the legislature reconvened, because we are technically not a committee of jurisdiction on this subject. And I knew that this subject needed to be both in this committee as well as appropriations to talk about. That's really not the responsibility of judicial rules to have those discussions. But there was nothing political on my part designed to exclude either you or Judge Grierson from the process. It merely came up that we had an available date that the committee could meet. We asked for witnesses to appear. You and Judge Grierson were not available. That is too bad, but the bottom line is we couldn't hold up things and then have it run into the time period when this committee was going to be meeting. There just isn't enough time to have that happen. As you've reported, COVID-19 has left us all in a pickle. And that's the upshot of why it is we met when we did. And when we realized we had all of these comments, we had the concern that said to us, it is time to bring this situation of a rollout to a halt and have those comments addressed. Now, you've described three important components to this system. I understand the next generation rollout. There is really not any complaints about that part of it that I understand. Maybe we agree on that, maybe we don't, but my understanding is you feel that that process is actually doing what it's supposed to do. The portal, I haven't heard a whole lot of conversation about whether or not that is actually working the way it's intended. But it seems to me from your testimony here this morning that the vast majority of comments are targeted at the third component. That's the e-filing piece of this. If the e-filing piece of this is what's generating the most problems, then I could easily see that letter being refashioned to say, please stop the rollout of the e-filing system until we get these problems ironed out. From a 50,000 foot level, and I say that only because I have not been trained. I have no reason to get the training yet because you're not coming to my neck of the woods until this, probably either later this fall or early spring. I don't know which yet. But the upshot is I'm not as involved in the system right now as somebody who is in the WOW district is. But the long and the short of it is, if there is agreement that the e-filing system is what's causing the problems, then there really ought to be, on behalf of Judiciary, a statement that you freeze that rollout in order for those problems to be fixed before that rollout continues. Otherwise, you are only adding to the number of people who are going to be complaining by the time it gets to my neck of the woods. One thing I do not know about, and that is whatever contractual relationship you have with Tyler, is there something that prohibits you from putting a freeze on the rollout of that particular component? And I'd like to get an answer to that question. And I'll end it this way. This conversation is really not the responsibility of judicial rules. It is the committees of jurisdiction that have control over how things are moving forward. But the intent on my part was to make sure the conversation happened as quickly as possible. And that's why Rules Met issued a letter. We can get into a battle over what that does, but there is nothing intended in that letter whatsoever to cast aspersions on the people who are working very hard in the judiciary to make this happen. There's a lot of frustration. That does not mean that we are casting aspersions on anybody. It simply means we've identified a problem and all of us need to put our heads together to solve that problem. No more, no less.
So I really appreciate the spirit of your last comments, because that's been our attitude all along in this project. When we have stakeholders who are willing to engage with us, that's very important information. In terms of the letter that was written, obviously we just received that Friday night. And so we take very seriously when any committee of the legislature, whether they have jurisdiction or not, expresses an interest and a concern in issues about the administration of the judiciary. And we're always open to having a dialogue about that in a venue that's well suited to actually get those issues resolved. I think we've joked before about the judiciary rules process. Before rules ever even get to your committee, we go through this very deliberative process, and some may say way too deliberative, but for better or worse, it's deliberative. It involves both people in the judiciary, and usually it involves, practitioners outside the judiciary. We have the whole process where once a rules committee comes out with a proposal, it's sent out to the whole bar for comment. Then it comes back, and usually by the time we get to the legislature, you already know that it's a pretty vetted process. And in the judiciary, that's what I intended to say. We're not in a political process here. We're more in a, judges and, find facts, and we get the evidence, and then it's weighed. And so we just have a different perspective on problem solving that's not the same as in the other two branches of government. And so it's important in a complicated project like this that we are actually able to talk to each other, number one, at the level of the people doing the work, so that they have that opportunity. And then let's say the people doing the work can't solve it. then maybe you come up to the management level to say, well, gee, these are the issues that can't be solved. And so sometimes, you know, it might be, well, we're just not imaginative enough. Sometimes we don't have the resources. Sometimes the players need more support. And that's why I've mentioned that for the state's attorney's office to actually do what we thought they were going to do, they would have needed resources beyond what they need for the old operations. They need strategic resources who can come in, whether it's from ADS or some other place, or a temporary employee of the judiciary, I mean, of the state's attorney's office, to come in and actually own that project and move it forward, and then work with us with a lot of knowledge so that they can be both a contact with their constituents or the elected state's attorneys, and also a contact with us. And we, as in the judiciary, really support that the partners in the justice system get the resources they need so that we can have that dialogue. So we welcome that dialogue. We welcome the ability to improve our whole rules and governance process, not just in the case management system where we have a very formal process, but also just the way the judiciary runs generally. It's all about that. And this is very unique.
Let me just say that this appears to be an issue that is post your creation of a rule and the deliberation process that goes into that. This is where the implementation process has surfaced many complaints, frankly, that could never have been anticipated in your deliberative process in issuing the rule. But now that they have been identified, moving forward on a rollout of the e-filing system that clearly has some problems, is only going to increase the number of complaints that you're getting. And while I agree with you that the resources need to be there, given the COVID-19 issues with our revenue streams, there's a high probability those will not be present. And then we have to figure out collectively how to deal with that absence. And right now, I'm concerned that continuing to roll out this one particular component is only going to exacerbate the problem while we try to get those details issued. So I guess if I'm saying anything, I'm saying that the letter, if it looks like it's too inclusive for what we have suggested by way of a freeze, narrow it down to what the problem actually is and freeze that particular problem so that we have the opportunity to put heads together and figure out how to solve those problems. Because otherwise we're all at cross purposes. And I'm as frustrated as anybody else here. I can give you a personal anecdote of today, but I want to talk a moment about an attorney that contacted me. You all know who Greg Nagurney is. Greg sent me a letter and he said, you know, the internet is basically free of charge. We've had a system in place for a very long time where e-filing could be done without any problem, without any vendors or anything else. And there's some truth to that, because the judiciary has been sending me notices of court hearings through the internet. And I've been expected to respond to those electronically, what I used to get through the mail. But conversely, I can't send something back like a motion to continue via email. It's been one way, and it's been very frustrating. Today, I have a situation where I've got a kid in jail, and on Monday, the judge asked that I come up with an assessment plan for this kid to get a drug and alcohol assessment before he would be released. Okay, I got the kid an appointment, and I do not have a system here that allows me to scan in a document to send it via email to the courthouse. The document was faxed to me from the provider. I have a fax machine. It's worked for 30 years. And I call the courthouse to ask if I can fax it down, and they say no. Well, I don't have a system available to scan in that document to place it on an email, which I'm glad they accept now because they didn't used to do that. So I email it down to, I faxed it down to the state's attorney, who tells me that their protocol is they will not deliver something from my office to the courthouse, even though they're one flight down. And that means when I've got to leave this conference in order to drive 10 miles down to St. Johnsbury and hand in the document before this kid has a chance of getting out of jail. That's an anecdote that demonstrates a problem with the system. That may be my own problem for having to bring my computer system up to speed to match what you're doing. But it is typical of some of the comments we're hearing about the interconnectivity of individual offices and people who have to go through the e-filing system. And it may be part and parcel of a whole lot of other conversations that have to be ironed out before we roll out that whole entire system to a different set of counties, because the problems are only going to get worse and the voices are going to get louder going forward, and we need to move in a different direction.
So
I'm getting a note from Jordana, and I appreciate that offer. I'm happy to speak with you. Thanks.
So, so the anecdote you just gave, I do feel that that's a problem that can be solved in a way that it doesn't require you to drive in the way you describe. But that's the sort of thing that happens at an operational level. And then if it doesn't get solved that way, then it gets escalated up. And so I really don't think that's related to the e-filing system. But if it is related to the e-filing system, you know, there are exceptions. Because you don't have e-filing yet in your county, you may not have read the e-filing rules. The e-filing rules have exceptions. And one of them is that for some practical reason, you can't e-file. You know, maybe your, you know, the system's down or, you know, what have you. And so I have them in front of me, but I don't want to take the time of the committee right now.
I don't want to, I want to kind of move here to Jordana has a few comments, and then Pat, if you can have the final word, because we're scheduled to take up your budget at 11:15 and now it's 11:22. And I appreciate, I think that if I heard that you would work with the users on the e-file system, that would be helpful. That's where the problem lies, I guess. Is that what I'm hearing?
So we have been working with the users, and we'll continue to work with the users, and we'll try to do it more effectively if the way we're working with them isn't effective. That is our commitment.
We are a political branch, no question about it. But when we hear from constituencies that there are problems, we try to respond to those problems.
Right.
And that's what this is about. This is not about picking on the judiciary or picking on you personally or anybody else. I just want to make that clear. From my perspective, I'm representing my constituents, whether it be a private attorney who's contacted me, a state's attorney who's contacted me, or a defense attorney. That's what I'm representing. I'm not representing anything else. Jordana, if you have a few comments, would like them, keep them brief, and I'd like to at least get to the budget by 11:30.
I do. Thank you, Senator Sears, and I will keep them brief. First of all, I would just like to respond to some of the things that Ms. Gable said, because characterizing all of the information that we shared related to issues with users' experience with the case management system and with the e-filing system is, negative characterizations of the work that's been done, wasn't even the purpose of communicating that information. The purpose was, there are problems, we would like to help work with solutions, to find solutions, and we'd like to solve them before it rolls out statewide and has a bigger impact. And so I don't understand, if the judiciary is so open to partnering with the users and working with us, why the feedback they're getting would just be, why the response to that would be, we're mischaracterizing what's happening. But as it relates to the email that Pat Gable mentioned, I am happy to forward it to everybody. But here's the issue. The issue that I was emailing them about was the service contact issue. I merely asked repeatedly, do I need personally, and do I need to direct every attorney in my office to go into each and every case that is in Odyssey, all the ones that were, converted from VTADs to Odyssey, and then the new cases that have been accruing, since the rollout in the new system. I go, do we need to manually go into each of those cases and add ourselves as the service contact? That information was not communicated to us when this system rolled out. In fact, the information, the e-service with Odyssey File and Serve instructions related to service contacts wasn't made available on the Judiciary website until sometime in July. And all I wanted was an answer to that question. I wasn't contacting Scott Woodward because I was having a problem using the system. And so the fact that, they offered some custom training to my office and I flat out rejected it is just frankly obnoxious and mischaracterizes the entire conversation. I was asking for a specific yes or no question. Do I need to make sure I'm in compliance with the e-filing rules, need to take this step because the program didn't do it automatically for us? And if that's true, I'm asking that the judiciary notify all of the attorneys so we can all make sure that we're slowly, adding ourselves, because it takes approximately 3 minutes to log in. You log in, you search the case or you enter the case, then you say view service contacts, and then you can add yourself. Once you've created yourself as a service contact and hopefully you checked make public, that information saved. So it's not like you have to type it in, right? But none of that information was available. So this offer of a custom training wasn't even the purpose of the conversation. And I still haven't even gotten a straight answer to that question. The judiciary claimed in the last time that I testified that they solved the problem around the service contact issue, and they haven't. What they did was update the instructions to advise attorneys to make themselves a public service contact. I looked up right now in the system this morning, and an attorney in my office has over a dozen aliases in the service contact because other people have created her as a service contact as well as herself. And that's not helpful to anyone. And we're going to have problems and we need to work together to solve them. But, saying that I testified to advance my own interests, I'm just a consumer trying to use this product effectively so I can do my job and be in compliance with rules. So, but the service contact issue hasn't been solved. The instructions have certainly been refined, but there hasn't been a simple directive to every attorney in the bar that they need to manually add themselves. And that's all I was asking. I didn't need a custom training because I have read, or skimmed, because some of them are too long and have sections that aren't applicable. But the user guides from Tyler Host and everything the judiciary has made available as they've made it available. So I wasn't asking for help using the system. I was asking for a simple yes or no question. And so the idea that they offered this custom training and I flat out rejected it, mischaracterizes the entire communication. And frankly, I feel like most of my interactions with the judiciary related to e-filing have had the same tone. I just can't get a yes or no. And I just wanted the record to be straight on that because I thought the characterization by Pat Gable related to that email, and I am happy to share it with everyone on the committee, is a complete mischaracterization of what the issue was.
So
Appreciate that.
with respect to the service contact issue, normally I'm the last person who should be talking about the details of the system. But that was, as a result of that issue being raised, the project team actually got together to evaluate that and actually did make changes. And so although historical references in the list need to stay in there because they're tied to particular cases, now it's not necessary to enter oneself. One can use, I think, what's called a public contacts list. But this is a perfect example where the platform that we have here is not, I don't know how to explain how limited our resources are. And so the same people who are, making available the information required to address the committee's issues are the same people doing the rollout, are the same people who are doing the training, are the same people who are designing new systems, are the same people who are installing technology. to help us during the pandemic. And so the interpersonal relations that get impacted by harsh communication really makes it so difficult for all of us, I think, to move forward in a constructive way. We, all I can say is, as I said before, we'll take very seriously the letter, interpreting it as actually I did, as requesting some change in our current e-filing schedule, and also looking at the issues in more detail. But I do urge any attorneys who are either on the meeting today or watch it later, please sign up for the trainings. They are there to help enable your use of the way you'll be interacting with the court system in the future. And it's essential that people participate in the trainings that are provided with the resources that we have. And if there's additional ways for us to support training, Matt Valerio said he was doing his own training. We applaud that. If there's anything we can do to help that, we will. I will say that there are judges who are willing to engage in more detail with the state's attorney's office regarding their issues. To some extent, when we've offered these things in the past, our offers have been ignored. And so I think it's important for the parties to continue to communicate. We're just going to keep trying to get better and better. That's what a new technology project is all about. It's a constant evergreen system, and it's going to work best when the parties are working together to improve it, recognizing the resource limitations. And
I think we can only do that if we don't mischaracterize
Hold on.
what each other says.
We've, you're perfect. I'm perfectly happy for you and Ms. Gable to have a conversation. I'm not sure I want to, I'm running out of time. And if we get anywhere today in terms of collaboration, I hope that Jordana and Pat Gable can have a conversation about how to collaborate better. There's been mischaracterizations felt from, I just got an email from Tracy Shiver over in Windham County, concerned about how she feels that her comments were also mischaracterized. So I think there's a lot of work to be done to improve relationships. I will say this from her email, Pat, that she's in complete agreement on one issue, that the docket clerks in Windham Superior Court have been fabulous and dedicated.
that's fantastic.
So I think there's a lot going on here. And while I understand the judiciary is not political, my advice is that you have a constituency out there that needs to be helped and needs to be worked with. And I think what they're asking for is help in implementing your new system. And if I can leave with that commitment for both all of the folks who've testified, the defense bar, the bar itself, as well as the state's attorneys, I think what they're asking for is collaborate with us. Let's make this system work. I'm
Senator Sears, this is John. Can I just say one comment? I'm at a loss for words, because mischaracterization is being very kind on some of the things that were said today, and I'm really disappointed. But I know you're short on time, so thank you.
Well, I appreciate that, John, but I think there's a lot. I'm happy to provide some more time in the coming weeks if it's deemed helpful, but I hope that in the short term we can get some collaboration going in the different groups.
Yes, and I think it'll be more productive in a different arena.
So with that, I thank all the witnesses. Are any committee members who have other comments that they'd like to make at this point? Joe, I'm sorry you have to drive to St. Johnsbury.
Well, I think Jordana has given me an idea, although I've sent it and I'm waiting to see if I get a confirmation back that it's been received. I'm just not used to sending documents through my telephone at the moment, and I'm learning on the fly here.
Joe, I'll look at,
No problem though, Jordana. I'm gonna come back to you and give you a phone call so you can walk me through it.
Everybody,
John
thank you very much.
Campbell Dick also sent me something. I'm not interested in getting, John, you know what county I'm in, so it doesn't take a rocket scientist to figure out who we're talking about. I don't want to advertise that over YouTube, but the bottom line is I need to fix my internal system to get caught up with what's going on. I'm not interested in placing blame on anybody.
Yeah, now, we're gonna take a 1 minute shift over to the budget, which is another problem because we don't have any money. And we spent some time talking about resources, and I got an email the other day from Matt Valerio telling us that because certain functions within the CARES Act aren't going to be covered for the Defender General, he's $400,000 short. So do I suggest we cut the judiciary by 400,000 or the state's attorneys by 400,000 to make it up from that? Or how do we deal with these tremendous financial problems that all of us are facing throughout the government? My hope is that Congress will act and provide more discretion, as the House of Representatives in Washington did, for use of CARES Act money so that Matt's 400,000 will be covered, and that they come up with a new stimulus package. But that might be dreaming. So in the meantime, we have to work with the reality of where the budget is. So if we could take just a 1 minute break, you don't have to shut us off, Peggy, but just kind of transition to the budget and get our budget documents out. And Pat, are you presenting that, or is Greg going to be doing it?
I think we're both available. It kind of depends on what level you want to talk at. Maybe I could introduce the process
Well,
we had with finance and management, and then Greg could talk about the
Yeah,
actual
I
detail.
would actually like to focus on anything that is above and beyond the governor's recommend.
Okay.
I'm not sure we can, this is one of those years, and I know we frequently have had efforts to improve the increase over the governor's recommend for the judiciary. I'm not sure that's going to be able to happen this year. So
Yeah, I
I'd kind of like
understand.
to
So,
focus on that if we could.
sure. So we'll take a break and then I'll
Take a
start and then
1 minute
make
break.
Greg's available to answer the questions about the detail.
Yep.
Okay, great.
Thank you. Okay, are we? I think we got a quorum if Senator Benning is back with us. Pat, I'm just kind of going over which document would you like to cover first?
So probably the FY21 budget restatement.
Okay, that's the, I think that's what I've got up on my,
Yeah, it's that's what the Ray is, FY21 budget restatement.
Yeah.
Um,
and it starts out with the first paragraph includes a reduction of $783,015.
yes, that's correct.
Okay, good.
So I could perhaps just give you an intro into our discussions with the executive branch. So you know that they sent out budget instructions requesting that all agencies and departments present a budget that cuts 5%.
Right.
And so we took a look at that and what that would mean. And what we communicated to them is that if the judiciary were to cut their budget, our budget, by 5%, we could only do that in collaboration with the legislature and executive branch agencies, because at the current time, both the Constitution and various statutes require us to provide services that could not withstand such a cut. And so any material cut like that really means some major changes. And although the judiciary, of course, is always willing to entertain major change if the other branches want to go in that direction, it was not something that we could do on our own unilaterally. We simply wouldn't be able to do that. What we did offer, however, was that for a combination of reasons, we had one-time money. And the one-time money is partly money that we've been trying to save up through vacancy savings to enable us to make certain improvements. And part of it came about as a result of the fact that due to the judicial emergency, some of the costs that judiciary normally expends were not being expended. Obviously, that's not payroll. Our payroll was normal, but items like travel, where the judges are normally traveling, the judges did not travel during that period. They're starting to travel again now. And so we felt we had one-time monies that we could offer. Part of that one-time money was money we were saving up to solve the 4D problem, which I won't go into, Senator, unless you want me to.
No, please.
But we did offer this money back, which means if we do have a 4D problem later, it will have to be appropriated to us to pay it. And so as a result, we offered back from these one-time monies carried forward from FY20 into FY21, a little over $1,400,000, which is an extraordinary amount of money for our little branch. And we proposed that in exchange for that we would not have our base budget cut. Finance and management felt that wasn't viable, that we needed to have a base budget cut as well. And I think this committee is well aware of our circumstance and knows that a base budget cut essentially means cutting the number of people who are working on various judiciary projects. So to comply with their request, we offered about $500,000 additional vacancy savings, which depending on what's happening at the time, we have to harvest those, could be judge positions. We can't really, at this point, with everything going on in the judiciary in FY21, have fewer non-judge positions. And so we're going to have to manage our workforce very carefully. And I think you can see why some of the extra attention that would be able to be offered that we were talking about in the previous part of the hearing requires people to do it. And so we're very reluctant without making sure everybody understands the impact to cut people. So that's what we offered when we understood there was a 5% cut that was going to go around, and of course ours was not 5%. As you know, thereafter, the revenue picture looked much better than it did before. But nonetheless, that was what we understood the governor was going to recommend. And I think at this point, if you go back and look at where we were, it seems like such a long time ago now, back in January and February, we were talking about the judiciary budget. We had a lot of issues on the table. Greg can talk about those in more detail in a second, but those issues in particular, the security spending issues that we have, we do need 4D monies, I think, in our current budget. And what I would do is just turn it over to Greg for the purpose of just reminding people of the other needs that we had to have the judiciary operate at the same level. The last thing I would say is if the legislature and appropriations is all in your bailiwick. So we talk about the things that we think are in our bailiwick. This is definitely in your bailiwick. If the legislature feels that it wants significant cuts to the judiciary budget, then we really do need to sit down together in some kind of committee or some informal way to talk about the places that the legislature would like to see cut in the judiciary so that we know how to respond to that. And so we think that this is not the year to do that. We think when all the technology is rolled out and we have some experience with the both the advantages of the technology and also the way it changes the way people work, that may be the time then to take a look and say, well, how are we doing? But we think FY21 is definitely not the time to make those changes.
As always happens, the judiciary, the appropriations process, and Senator Nitka and I obviously are on appropriations, is one that's pretty holistic. And it's usually based upon the governor's recommend. And, if you can find funds somewhere else, it's always been great to have those one-time funds. Those are gone. It's always been great to have access to more federal funds, and we don't know what's going to happen. I think there's going to be a heck of a budget adjustment in January, depending upon what the federal government does. But right now, if we're looking at just funding at the governor's recommend, we've been talking in judiciary, had nothing to do with, talking in appropriations has nothing to do with the judiciary itself. But you've got certain priorities of the governor that may not match the priorities of the legislature, but in mixing those two together, trying to come up with money, we're already down. I mean, if we figure out how to do $30 million for the state college system, if we don't agree with the governor, then we've got to find 30 million. Those are the kinds of things that always go on. So I'm actually prefer to focus on what it is above the governor's recommend that the judiciary is requesting. As you know, the House has, over the years, has been less inclined to fund your security at a level that you've requested, and the judiciary has tried to catch up on some of the security, but it's never gotten. I mean, the Appropriations Committee has in the Senate has tried to increase that, but has never gotten to the level that you actually requested.
Yes, and so I think.
So what is it that, I guess my question for Greg or yourself is, what is it that you're recommending above the governor's level?
So Greg, over to you.
Hi, and thank you. I think what I'll do is I'll just speak directly from this memo.
Yep.
Towards the bottom of page 2, I've listed the judicial priorities that are not in the governor's recommend. And these are essentially the same that we submitted in January. So these priorities have not changed. Not sure if I can share my screen or if Peggy would do that.
No, I think I don't know that it's necessary. Peggy, do you want to try to share the screen with this document if you can?
Well, I can just speak to the issues.
Yeah, I see expansion of the courthouse, Costello Courthouse, 85,000.
Yeah. Yeah. So the first one listed there in the memo is actually the anticipated Title 4D decrease in revenue, which, this is an ongoing, evolving problem. And at our best guess at the moment is that the judiciary will incur about a $350,000 loss of revenue based on changes to that Title 4D system. That's still a pressure that will be there for us. The exact number has yet to be determined, so that's an estimate.
So that's actually a revenue, that if you don't get that 350,000, you'd have to cut elsewhere.
Yes, our expenses, are obviously tied into staffing, and we expect that there'll be a revenue decrease. We actually incurred a revenue decrease this past year in FY20 when we closed out in our Title 4D program. We expect that it'll be 350,000 in FY21.
Okay. And then we go to Costello.
And then the Costello, and that's simply a fee for space charge that we'll incur. This is the ground floor of Costello in our Burlington courthouse, where probation and parole used to be. They have already moved out. And we are planning to put in a resource center, an access and resource center on that ground floor to help with access to justice. And we're already in there, moving desks around and checking ports. We haven't actually moved staff in there yet. We do expect there'll be some sort of construction and fit up as we move in. We do have a small budget to do some rearranging, and we're working with the National Center of State Courts to help us design what that resource center will look like. The only expense that's not covered in this plan is the increase in fee for space charge that we'll incur. The next two costs that are listed in our memo are related to court security. So we had made a request for 5 additional security officers. That cost is $375,000. What's interesting about this is that 2 of those positions in the Barry Courthouse have actually been funded in one-time funds out of our BAA request from last January. And we have filled those 2 positions. And so if we do not get some funding in this area, there's a chance that we'll be downsizing our security force. We had previously made the determination that the Barry Courthouse could not continue with 3 security officers, and we upped it to 5. So that would cause a problem, an immediate problem, if there were no funding there. The other 3 positions would go to other courthouses around the state, depending on the need. Costello is probably high on that list, but those 3 positions are not yet determined. There's also the next listed pressure would be $125,000 for an increase in the sheriff's and contractors' rates. This has been the ongoing issue every year where we come in and we ask for an increased rate because what we're paying the sheriffs is significantly less than what the executive branch is paying. And the sheriffs are aware of that. They make us aware of that on every conversation we have. And this is an ongoing pressure. Now, what's interesting is in the governor's recommend, we had originally, when we submitted our budget to the governors, to finance and management, we had requested $250,000 for an increase in the sheriff's rates. And the governor's recommend includes half of that, $125,000. And so we've listed here the other half of that request. So it's partially funded in the governor's recommend.
Yeah, I mean, this is one thing that's happened, and I'd like a response. Were there any savings from video arraignments that are built in here? Because, I mean, obviously there was always a conflict between this committee and the judiciary regarding video arraignments, but they've happened due to the pandemic. And I'm curious if there's been if you don't need as much security, that sort of thing.
Actually, our experience has been the opposite, that we have a higher demand for security now in the pandemic. Yes, there are fewer in-person hearings, which decrease the need for in-courtroom security officers. But what has happened is the monitoring and the screening at the front door has increased. It's much more complex now as we ask survey questions, and we're doing all the PPE and protocols at the front door and the screening, along with monitoring throughout the courthouse of social distancing rules. So I've been fielding more requests from court managers to increase security, particularly when there's a particular hearing, an in-person hearing, or a particular day when the number of people coming into the building is increased. We tend to have more of a roving presence throughout the building and officers asking for compliance with masks and social distancing rules. So,
and Senator, you'll recall that the transport budget isn't in the judiciary budget.
No,
So,
I know.
yeah, so we wouldn't know about that if that has any savings.
Yeah, but I just thought that security might be down in the courthouses because the arraignments are being done remotely. So that was my specific question, and Greg answered it, unfortunately.
When this pandemic first started, I think it was late March when we made a statement to the sheriff's departments that we would support our existing contracts with them until this got sorted out. And as it has gotten sorted out, we've realized that there haven't been any areas that we've been able to decrease security staffing, and we've received an increase in requests for whenever a manager requests an additional officer, they have to send it to us so that we can review it and see if we have the money for it. And so those requests have increased.
Okay. Well, no, it was just a question. I understand that the transport is a different matter.
We
And
dealt with transport yesterday.
Ah.
The last pressure that we've listed in this memo is to shift some salaries. What's mentioned there is RAS staff salaries. RAS is our IT office. And we would continue to request that we shift those salaries from our court technology fund over to the general fund. This is an ongoing request that's happened for the many years now, 3-4 years that I've been here. These positions were inappropriately put in the Court Technology Fund back when the Judiciary was having a financial crisis around 2012 or 13, I think. And the plan all along was that these positions would be shifted back to the general fund when it was able to do that. It's about $258,000 for 3 positions. And what we're seeing in the technology fund is the revenue decreasing there. It's based off of tickets and fines. And we've had our FY20 closeout, and it was our worst year in the past 7 years. And so that fund, which is designed to support our technology, is starting to shrink. And we'll have to do something there very soon. It was down almost $300,000 from our budgeted amount just this past year.
So to sum it up, Greg, you're at about 1.2 over the governor's recommend?
With all these pressures, yes, it's about 1.2.
All right. I was about to say, I'm glad I'm not on appropriations, and I realized I am.
Senator, I did want to add that just as I think the executive branch has been doing, we've been under what they call a soft hiring freeze, which means that we're looking very carefully when a vacancy is created to try and continue to capture savings where we can, and only filling positions when they're vitally strategic. And we, of course, are continuing to try and find savings during this tough year. So we understand the challenges that face the state. FY21 is a challenging year, but we're getting through it. We're very worried about what will happen in FY22. And we agree with you that there's so many things that are unknown about that, that all we can do is try and operate as efficiently as we can as we await events to unfold.
Well, I appreciate the presentation. Goes without saying, we do the best we can, but I have to, without help from the federal government in loosening the restrictions on the CARES Act funding that we received earlier, and without help in another stimulus package that helps the states and local governments, I don't see how we make it through it without significant cuts. And I think you're very wise to be even more concerned about FY22. I think that promises to be another problem year that we're all confronting. And I suspect that it'll be FY23 before we find our way out of this morass.
Yeah, I do believe it will take collaboration between the branches when we look at the judiciary and the justice system generally. Where are we going to withdraw resources, and where are we going to invest resources during that tough period? I think we're the justice system is too interconnected with others for us to be doing that alone. And we really want to follow the legislature's will on what it wishes to be funded. So once we know more about that, it'll probably be good for us maybe to sit down and talk about how we can have a discussion like that.
Well, I was hoping to come up with a 2% reduction from the governor's recommend, but it looks like you're looking for 2 million, 1.2 million more. The committee will, any comments from committee members before we adjourn for today? I'm sorry that we didn't have enough time to really delve into the budget, but it's helpful to know what you're asking for and how we can help best.
Yeah, and we're happy to answer questions offline or come back in again. We're prepared, along with the other branches, to tighten our belts and do what we have to do to get through this period.
Any comments, questions? Great, thank you all very much. And I want to just remind everybody on the committee, tomorrow we're going to deal with start out dealing with the House updates to S-119, the use of force, deadly force policy for law enforcement. And
remember, I won't be there unless I.
and you
can
will
find
be
your
there
house.
and you'll be here in spirit or at the library in Keene or somewhere that has internet.
Hopefully someplace sitting outside a library or someplace will have it for me.
Well, the good news is you can't go inside.
Yeah.
Hopefully it's a nice day.
Yeah.
All right. See you all tomorrow. Thank you.
See you at 1, I think.